Good morning. This is Judge Alyssa Perez resuming the civil docket for the 210th District Court for February 8, 2023. Again, all matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufa, would you call our next case, please?
In cause number 2021, DCV 3781, Silvia Cortez versus Dollar Tree Stores, Inc. Announcement to council, please.
Good morning, Jonathan Baeza on behalf of Ms. Labanati for the plaintiff, Ms. Cortez.
Good morning.
And Steve Barnett here for defendant Dollar Tree.
Good morning. Final status conference. How are we doing on this one?
We're doing good, Judge. We have a February 14th mediation with Mitch Moss. We're hoping that we can come to an agreement there. And if it doesn't, I think we're ready to go to trial.
Okay. Then we will not see you all until the 1st. So good luck on Valentine's Day. Everybody wear red and just think in the spirit of happiness.
Didn't even know. I didn't even realize. Oh no!
Oh, come on, Mr. Baeza. Come on. All right. Good luck, guys. Now we'll see you on the 1st. Well, we'll see you on the 1st anyway. Good luck.
Thank you, Judge.
Take care.
Thank you.
All right. I feel like I see is not everyone here on 3335.
No, Judge, we still need the plaintiff, but I have the number 3 here, Judge. Number 3 is complete.
Okay. Go ahead.
In cause number 2022, DCV 2486, Terry Finklia versus Pay and Save, Inc. At all. Announcement of council.
Jonathan Baeza for Daniela Labanati on behalf of the plaintiff.
Hugh Lyle here for Pay and Save.
Good morning. I had this down originally for a scheduling status conference, but I believe there's been a motion for continuance that I asked to be added on today because I think the setting on that is probably next week. I apologize. I'm wrong on that. But let's hit that motion for continuance first. I didn't see a response, although I think we kind of, well, I'm not going to assume anything. Go ahead, Mr. Baeza.
Mr. Kim is also here for the newly added defendants, EP Samana and Mesita Investors, Judge.
Oh, my apologies, Mr. Kim. Okay.
Good morning, Your Honor.
Good morning.
Okay, if I may proceed, Your Honor.
You may go ahead.
Okay, so this is there's a motion for summary judgment that was filed in October of 2022. There was a third-party designation. Within 2 days of that third-party designation, plaintiff joined EP Mesita and EP Samana as defendants. There were still some amended MSJs. We answered those. Finally, the judge granted a continuance for 90 days in November 9th of 2022, which takes us to February 9th of 2023. MSJ set for next week. However, we have not been able to schedule yet the corporate representatives' depositions of EP Samana, Mesita, or Pay and Save Lowe's. Mr. Kim's office and our office, we've agreed tentatively on some March dates for the corporate reps of the EP Samana and Mesita corporate reps. However, Mr. Lyle is opposed to this motion to continue the MSJ, so we haven't been able to set those. We're hoping today we're asking the court to extend that a little bit. We do have 3 lawyers, probably 2 to 3 different corporate representatives. We have tried. We tried to get deposition dates in December. Tried again in January. We were successful in getting some proposed dates from Mr. Kim's office in January. And I believe, if you may recall the last hearing, these corporate rep depositions are fairly important in order to decide who's responsible here, Judge. And I mean, MSJs are usually taken up after some discovery is done. We've done paper discovery. We just need those corporate reps, but that's where we are right now, Judge. We would ask for a continuance, and I mean, if we can schedule it for March. I believe the dates were in March 2024, something like that.
So if we continue the summary judgment, you're saying for March after you hopefully get depositions? Is that what you're saying?
Yes, Judge.
Okay. Anything else?
Nothing from plaintiff, Your Honor.
All right, Mr. Lyle.
Yes, Your Honor. The we understood this just to be a status conference, and quite frankly, did not know that the court was going to entertain the hearing on the motion for continuance. A response was filed this morning
Oh, okay.
to it. And you will recall that the last time that we were here, the motion was set. A hearing, a motion for continuance was requested. The request was for 90 days. The court granted that. During that time, no additional discovery has been done. As far as you know, there was some interrogatories, some written discovery, but insofar as the depositions of the corporate representatives, those have not been taken. And when there was an email back in December that was sent out to all parties saying they wanted to take depositions and listed the areas, I contacted my client and was able to figure out who within the company would fit those. But I never heard anything from Mr. Kim. I never heard anything more from plaintiff's counsel. And we continued on forward with the idea that one continuance had been granted in order to allow them to conduct that discovery, and it didn't happen. We talked about this the last time there was a motion for continuance filed, and with regard to a motion for continuance on a summary judgment, one of the things that has to be shown is due diligence. And there's not any due diligence here, and it's not any due diligence in the affidavits, the verifications, or anything about what plaintiff has done or not done that has prohibited them from doing what they needed to do in the 90 days that the court gave them since the last time this was continued.
Okay, Mr. Biasa,
In response,
yes.
in response to that, I think Mr. Lyle just said he did receive an email asking for dates with the topics. He did talk to his client. Notably, he did not contact the individuals, me, who asked for the dates. So I'm not going to set them unilaterally. I can. That usually leads to a motion to quash, especially with two attorneys involved and two calendars. So then I resent an email in January asking for additional dates, and Mr. Kim did respond. It was the end of January that Ronnie with my office sent the email asking for additional dates. And Mr. Kim's office did respond. And I did have a conversation with Mr. Lyle, and he said, I can have my corporate representative available for you tomorrow. I said, I can't take the deposition tomorrow, and Mr. Kim would likely need to be there as well. So we had to say no. Motion was my motion to continue was opposed. Here we are today, Judge. There's only so much we can do in scheduling with other individuals. Besides setting unilaterally, and I believe in El Paso County, we try to agree on things, Judge, rather than set unilaterally.
Okay, I was just inquiring with the clerk, Mr. Lyle, and it looks like they just accepted the written response. And so I will need to look at that. I don't know, Mr. Kim, do you have any input here? I don't know.
Mommy and daddy are fighting. So, Your Honor, looking at when the petitions were filed, answers were filed, it looks like Pay and Save filed the answer October 14th or 15th, I believe. We filed our answer November 15th. We're not even, I think, 4 months in, if we count from the date disclosures were due on December 15th. So it's very early on. We have not had a chance to inspect the premises where the incident allegedly occurred. I understand that it's off a curb with the border of the parking lot. And there's some issues between my clients, EP Samana and Pay and Save, that have to be hashed out. And so I think the traditional motion for summary judgment is a little premature at this point, because we do need to at least conduct depositions and an inspection to get to the bottom of this, because there is a genuine dispute between Pay and Save and EP Samana as to who was responsible for this particular area I think, if we have to respond to it, I mean, we can file a response and attach it at the contract. And we can argue about definitions. But I think at this point, it's a little premature.
So let me just take a look at this response, Mr. Lyle. I think, it might be repetitive of what you've stated today, but I do want to look, since you actually filed something at it. I'm going to reset the scheduling status conference for next week as well. So let me look at this response. Next week we'll do it at the same time, whatever time, I think it's 10 or 10:30 for next week. And I'll have a decision for you on the motion for continuance. I would anticipate by the end of the day. I just want to make sure I read Mr. Lyle's pleading. Okay.
Yeah, the only other thing that I might add is that, I would tend to agree with Mr. Kim or Mr. Baza with regard to a no evidence summary judgment. Absolutely. Unfortunately, the rule with regard to traditional says that summary judgments can be filed at any time, period. And it's now been however many months now that it's been filed, almost 4 months. And if anybody wanted to oppose it, they certainly could have, done something. But anyway, I appreciate the court's consideration.
Absolutely. We'll get you a setting for next week at the very least for the scheduling status conference. Okay.
Thank you.
All right. Thank you very much, gentlemen.
Thank you,
Judge,
Judge.
may I?
Monday.
The response to the MSJ is due today. I mean, I've already responded. I don't have much to add. I've responded. I've asked for a continuance. So I think I've responded twice. It would just be repetitive. So
I'm fine. Just let me deal with the continuance. Okay.
will do. Thank you, Judge.
All right. Thank you, gentlemen. Y'all are excused.
Bye-bye.
Who's next?
Staying on page 2, Judge,
Mhm.
in cause number 2020 DCV 3335, Melissa Jenkins et al. Versus Ryan E. Martin et al. Announcement of council, please.
Greg Marks for the plaintiffs. Your Honor, Carlos Rincon, Brad Peterson, and Bill Minucci for the Ford Motor Company.
Good morning, Your Honor. Maxwell Damon appearing on behalf of defendant HMV Trucking LLC and defendant Ryan E. Martin.
And good morning, Judge. I am the guardian ad litem assigned by the court to represent the minor, Al Jenkins, in this case.
Good morning, everyone. So we're here at a final status conference. Let me kind of parcel this one out. Mr. Bayman, Ms. Mendez, we had a friendly suit set back in December. Can you just refresh my memory? I mean, we had it scheduled. I should say we had it scheduled. Where we were with that, because I think there was not a follow-up or a rescheduling. And honestly, I'm not remembering why we passed over that.
Your Honor, I'm sorry, Ms. Mendez.
No, go ahead. Go ahead, counsel. That's fine.
Your Honor, my understanding was that there were a few hiccups that had cropped up post-settlement that have made it impossible for Ms. Mendez to render an opinion on the terms of the settlement at this juncture. Specifically, and Mr. Marks, correct me if I'm wrong, I believe there's some ERISA benefits that Ms. Jenkins, the plaintiff, had received, and the value of those benefits that were paid, the value of that lien exceeds the value of the settlement. And that plan has apparently refused to work with Mr. Marks or his co-counsel on reducing the lien. I think there was some discussion of workarounds for that, like seeking either declaratory judgment or placing the settlement into the registry of the court pending resolution of the case. But right now, we don't really know the status of that. And then the second hiccup, I believe, was that there may have been a separation between the plaintiffs, Mr. Jenkins and Mrs. Jenkins, that created some potential issues.
Okay. All right. Just wanted to follow up because I was trying to think of everything that had happened. I hope, Mr. Peterson, I think you had a softball tournament back at the beginning of the year. So I kind of had you all divvied out, but we're all here today. Final status. We're still specially set in April. So Mr. Marks, how about we start with you? Or how are we doing status wise?
I think we will be ready for trial come April
12th, I think it is, or 14th, or whatever date it is.
14th. We have our docket call on the 12th. Okay, sounds good. I know we had pushed it back. Anything else?
Not from the plaintiffs, Your Honor.
Okay,
Just so the court is aware, I am speaking with the subrogation / lien holders, and we are trying to work through some things, not just on with respect to the trucking company, but with respect to all the defendants. So I am working on that. So
okay. Well, I only have you all coming back on the 1st of March. I'm kind of, let me see. It leaves at about a month or so, a little over a month before trial. I don't know if it's worthwhile to bring you back maybe the week before we have our docket call in case you all have an update, but if I can rely on you to get with us with plenty of time. I remember in scheduling this, we made a point of having this number one for that trial week. So I want to make sure that if there's anything that comes up, I have a little bit of notice so that if we need to reschedule or, for the other cases that are on that docket week, I'll know what I'm doing. So I'll just check in with you on March 1st and we'll see how we go from there. Okay, gentlemen. Miss Mendez. Okay.
Sounds good,
All right.
Judge.
Appreciate. Thank you very much.
Thank you.
Hi, Judge.
Who's next?
Top of page 3, Judge.
Mhm.
In cause number 2021 DCB 2365, Farah Olivia Jones versus Jose Renteria Lopez et al. Announcement of council, please.
Good morning, Your Honor. Manny Morgan on behalf of the plaintiff, Ms. Jones.
Good morning.
Joshua Murphy on behalf of defendant Progressive, Your Honor.
Oh,
And
okay.
Greg Chandler for the defendants Lopez.
Good morning. Final status conference. Oh, there's some kind of motion for continuance. I can't see the pleading, but I see the entry on Odyssey. What's going on?
Yes, Your Honor, we are presently going to mediate this case on April 7th, and I believe that is the same day that we have trial set. And so we agreed with the parties to continue, if that's okay with the court, Your Honor.
Well, that's going to be great because I believe this might be one of the last cases that we still have a setting on April 7th, but that's Good Friday. So we're closed. So, continuance granted. Let's not set you for a status on April 26th.
Okay.
We'll reconvene after that April 7th, and then see where we go from there if we need to. Okay? That's good, everyone?
That
Yes.
sounds great.
Thank you very much. Y'all take care. Who's next?
Staying on page 3, Judge, in cause number 2020 DCB 0005, Carlos David Dipona versus Hector Mercado. Announcement of council, please.
Good morning, Your Honor. Nicolas Ocampo on behalf of plaintiffs. Sorry, my camera is not working today.
Okay.
Morning, Your Honor. Juan Carlos Garay on behalf of the defendant, Mr. Mercado.
And I believe, good morning, we reset this a couple of times. We had a motion to withdraw pending. We're set for trial at the end of the month. Let me see, is it Mr. Licona? Is he here?
Yeah, no, Your Honor. So I was able to speak with him and I kind of explained the situation of the withdrawal and everything. And he decided he's not going to be proceeding with the case. He gave me written authorization to dismiss the case yesterday. So I spoke with Mr. Garay today, and we just need a couple of days to get the dismissal documents to the court.
Okay, I'm going to go ahead and set this for a dismissal hearing in 2 weeks. If we receive the documents ahead of time, great. We don't come back, but it'll be my opportunity to follow up with you. Actually,
Judge, may I just mention something though?
Yes.
I do need to speak to the client because I appreciate the plaintiff has offered to dismiss the case, but there's a counterclaim and I need confirmation that I can dismiss the counterclaim as well.
Okay.
And those are the negotiations, but I have not been able to get a hold of my client this morning.
Okay, no worries. My apologies for not recognizing that. I'm going to leave the settings as is. We've got our docket call on February 22nd. If everything gets squared away, great. I will see all the paperwork from you all ahead of time. If not, we'll do on the 22nd, okay?
Yes, it should be sooner.
Absolutely.
Thank you, gentlemen. Y'all take care.
Thank you, Your Honor. Have a great day.
You too. Who's next?
Staying on page 3, Judge, in cause number 2022 DCV 0720, Michael Richard Romero et al. Versus Union Pacific Railroad Company et al. Announcement of council, please.
Lloyd Rab, Your Honor, on behalf of Michael Romero, the plaintiff.
Good morning, Your Honor. Taria Hutchinson on behalf of the defendant, Union Pacific Railroad Company.
Good morning. So I have this down. Let's see. Yes, there was a motion to quash back in December, and I think there is an answer that was just filed yesterday. And so motion to quash, motion for protective order. Mr. Rob.
You ready, Your Honor?
Okay.
Okay. There is no dispute in this case, and the defendant doesn't dispute it. The defendant, Union Pacific Railroad, is entitled to receive records related to the medical condition plaintiff has put in issue. Our statutes, the courts, and court rules recognize defendants' entitlement to those records. Those same statutes and court rules recognize plaintiff's right to be protected from disclosure of private information. That protection is provided to prevent unauthorized use of information, not simply because it's irrelevant, but to protect the privacy of every person, including injured persons. This case, Your Honor, is not a typical injury case. In a typical injury case, the plaintiff and defendant do not know each other. The only thing that brought them together was the incident which caused the injury. Plaintiff and defendant in the regular injury case have no relationship before, during, and will not have a relationship after the litigation. Yet our legislature and the courts have protected plaintiffs in that typical injury case from disclosure of privileged information, from the invasion of the federally and state protected rights that a person has, and specifically to care and conditions which are not related to the injury. With this, the defendant agrees, as was in their reply, which they filed at 4 o'clock last night. In this case, however, it is not the typical injury case. Defendant Union Pacific Railroad is the employer, and Mr. Romero is the employee. Union Pacific had, it has, and it will have, after this litigation, absolute control over Mr. Romero's ability to earn a living and provide for his family. Because of this absolute control over Mr. Romero's ability to earn a living and provide for his family, and Union Pacific's ability to use the information obtained in the litigation against the employee, this litigation and the future of his employment requires more scrutiny by this court and the information which is to be obtained and allowed. Now, Union Pacific regularly asserts, and defense counsel will not dispute this, that it, Union Pacific, must determine the medical qualifications of its employees to work on trains and around railroad equipment. It, and only it, determines that an employee is not medically fit to work on the railroad. It has a process under the collective bargaining agreement to obtain the information to determine medical qualifications of an employee. If Union Pacific obtains information that it, and only it, determines that the employee is not medically fit to work on the railroad, it will take adverse action, including termination of the employee. And it regularly terminates and suspends employees for medical conditions. Now, in the typical injury case, what defendant obtains in the litigation discovery is never used against the plaintiff except in the litigation. This case, as I said, is not a typical injury case. The information Union Pacific obtains based on past, actual, and Union Pacific's practice has the substantial risk to be used, if at all possible, to the railroad's advantage and adversely against railroad employees. Such adverse action isn't minor. It is huge to the employee because it affects the employee's ability to provide for his family and to earn a living. Because of this, or because this isn't the typical injury case, and his employer will, if it has the ability, use all information it acquires, whether relevant to the issues in this case or not, against Mr. Romero and affect his ability to earn a living for him and his family. Mr. Romero is looking to this court to protect him and his family now and into the future from the disclosure of information which should not and need not be disclosed for any issue in this case. Specific to the records sought by Union Pacific, Union Pacific sent a notice of intent to take the deposition by written question of 15 healthcare providers. We contacted defense counsel Ronnie Turner and raised these issues with him. He agreed at that time to withdraw all objections except related to the pharmacy records through Albertsons. And I have to tell you, Judge, despite or in spite of the specific agreement that we had with Mr. Turner, where he withdrew or said he was withdrawing his request for records and for the depositions, they still requested the records. Mr. Romero received a telephone call from one of his healthcare providers where Mr. Turner's office had contacted them to get the records. That is why Mr. Romero needs protection. Now, Your Honor, pharmacies have records of all prescriptions and only prescriptions ordered by all of plaintiffs' doctors. The prescriptions relate to injuries, which are a condition in issue, and prescriptions related to conditions which are not at issue. So pharmacy records contain a mix of information, those which the defendant is entitled to, and those which the defendant is not entitled to. If a defendant obtains all prescription records from a pharmacy, it will obtain records related to medical conditions not related to this case. That violates the statute, the court rules, and court decisions. Defendant has the information it has requested from it wants from the pharmacy. Keeping the pharmacy records from the defendant doesn't deny it any of the information which is relevant. Specifically, pharmacies do not fill prescriptions without doctor's orders. Doctors document all medications in the patient's records. So the doctors make a notation of the prescriptions they are ordering, and it is in those records. The defense is not sitting here telling you, Your Honor, that it doesn't have those doctor's records and therefore it is denied that information. It is simply saying it wants the pharmacy records, but it has all the information about the medical treatment as well as the medications prescribed for the specific condition in issue. So any contention by defendant that does not have Mr. Romero's prescription records is ignoring the reality that prescriptions are contained in the doctor's medical records. Defendant is not saying it doesn't have those records. The question must then be asked, why does defendant need pharmacy records if it already has the prescription information? And the answer is simple. It's phishing, and phishing discovery is not allowed. The most important reason why we are here today is to protect Mr. Romero's job, to prevent his employer from getting information it is not entitled to and using it against him in the future. Mr. Romero is asking Your Honor and the court to help protect him and his family and their livelihood with this motion. Thank you, Your Honor.
Thank you, Mr. Rabb. Ms. Hutchinson, I am just pulling up the response that was filed yesterday, so I'm probably going to need a little bit of time just to look at that, but you may proceed, you may respond.
Thank you, Your Honor. I will start by responding to, I think it's the second or third argument of counsel regarding the ordering of records. He has been told by Mr. Turner that there was a miscommunication on our part as to some of the records that were ordered. He and Mr. Turner and counsel did have a discussion regarding canceling and agreeing to cancel some of the DWQs that had already been ordered. Mr. Turner believed that that order was canceled, and it wasn't until we received the alert from plaintiff that those orders, that those medical records were in fact ordered. And so as soon as we found out, we did cancel, I believe it's 4 of those records were canceled immediately. It was already too late though to cancel 2 additional records. And so we do have in our possession 2 sets of records. It's the El Paso Sleep Center and the El Paso Ear, Nose, and Throat records. Those records are in our possession, but we are here today to tell the court that we have not looked at those records. We're not going to open those records up because we do understand the agreement that was on the table. However, there was miscommunication. And so because of that, we tried our best to cancel all those orders, and the ones that were left over was those 2 records, and they have not been opened in order to maintain the agreement that was made between Mr. Turner and counsel. As far as why we're here today, regarding these Albertson Pharmacy records, counsel has made a myriad of allegations against Union Pacific that in fact are just untrue. Union Pacific has not provided any evidence, nor will they, that shows that the litigation that's here and we're here for today will affect Mr. Romero's ability or opportunity to come back to Union Pacific. Nor will these records be used against him when if he wants to return back. Union Pacific's position has always been that if he wants to return back, he can. We would love for him to come back to work. But this is just, unfortunately, under the FELA laws that are set, this is just a part of the process. And we're trying to delineate between what is a normal negligence lawsuit and what is this case. At the end of the day, this is a personal injury lawsuit where Mr. Romero, the plaintiff, is making numerous allegations and saying that his injuries has caused him to be injured and seriously injured to the point of, I think he's claiming, let me see, he's made numerous, he's saying that he even has continual pain from these injuries, from his ankles, his knees. He's still having pain in his right hand. He's having memory loss. And so because he's saying that he's having continual pain, the courts have said that that is relevant information as far as his medical and his pharmacy records are concerned. Just because the doctor provides you with some type of prescription does not mean a patient has to go and get those prescriptions. And so for us, we're trying to obtain the pharmacy records regarding this incident to make sure that he in fact did get those prescriptions. And if he did, then we want to know so that we can effectively defend this matter. And so that's what the courts have said when it comes to what's relevant when it comes to the medical and billing records. We want to make sure that the contentions that are made by plaintiff, we're able to properly defend them. And so in order to properly defend his claims and his contentions against us, we need to see his full set of medical records that are relevant to this incident. And because the plaintiff has made, and in the response you'll see, we put in his interrogatories, they listed out the pharmacy records. They listed out Albertsons. They've also listed out that he is continuing to have pain in all of these areas. And so therefore, we can assume that he's probably taking prescriptions. And so we should be able to see those prescriptions to see just what is he taking, not what the doctors have ordered him to take, but what is he actually going to fulfill to help him with his injuries.
All right. Mr. Rabb, you have anything else?
Only briefly, Judge. It sounded like Ms. Hutchinson was implying that Mr. Romero isn't back to work. He is back to work and has been back to work for a long period of time and has been working for the railroad. The problem that we have here isn't trying to keep records from them. We agree they're entitled to records that are related. The problem is what's going to happen after this case is over and what they will do with those records. I've been litigating against Southern Pacific and then Union Pacific for 38 years and have been involved in the union and as well as all matters related to employees on railroads in El Paso, all the way across Southern Arizona into California. And I'm going to tell you that Union Pacific will use whatever information it acquires, no matter how it acquires it, to its advantage. And so Mr. Romero just wants to make sure that he isn't disadvantaged by them getting something they shouldn't get. If nothing else, Your Honor, we would request that any records that they are asking for, specifically the pharmacy records, are reviewed by you in camera so that Mr. Romero can be protected as well as his family.
Okay. All righty, so this is one again where Ms. Hutchinson, I do want to review the response briefly, but I don't anticipate it being a long period of time for me to go ahead and review this. I don't know if you had a proposed order, Mr. Rabb, on your motion, specifically with respect to the protective order, but if you do have something, if you will email it to Ms. Hernandez, the court coordinator, I want to kind of wrap this up this week. I see in terms of our calendar that you all aren't coming back till September, and that might change if you all have something that you need a hearing on, but I'm going to leave everything the same. We're set for trial in November. So I'll have this squared away by the end of the week. I just do want to review that pleading. Okay.
Thank you.
Thank you, Your Honor.
Thank you. You all are excused.
Thank
you.
Who's next?
Number 3 on page 1, Judge. In cause number 2021 DCV 2669, Melissa Woolley versus Charles Richards II et al. Announcement of council, please.
Mr. Marufo, I think you may have put two cases together.
So is it cause number ending 2669? That should be Mr. Hirsch and Mr. Madrid who are here.
Yes.
Okay, so 2021 DCV 2669, Melissa Woolley versus Classic Ventures. May I have announcements, please?
Good morning, Your Honor. Michael Hirsch for the plaintiff.
Your Honor, good morning. Hugo Madrid here for defendants.
Good morning, gentlemen. I think we have a summary judgment set next week and then bench trial in April. How are we doing on this one?
So, Judge, on this one, we've given the appeal. We've had that came back down and we've done discovery. We filed last night our motion to compel mediation. We think it's a good time to mediate this case. And in addition, we filed an amended petition that should alleviate the need for the MSJ hearing next week. And we did get mediation scheduled. I believe it's on March 7th. Is that correct, Mr. Madrid?
That is correct.
Okay, so with that, are we, let's see, March 7th, that puts us a day before our final civil pretrial. So we're good to go past the February 15th setting? Can I still have you all come in on the 8th? That being too, yeah, we'll just check in with you then. We'll go past that February setting and then go to March 8th and hopefully March 7th is good.
Judge, that'll work.
Okay, let's do that. And I won't move anything else. If we need to change anything else, we'll consult on the 8th, okay?
Okay, thank you, Your Honor. May we be
Thank
excused?
You may.
All right, thank you very much.
I have
Who's next?
one other matter, Judge.
Which is the other one? On what page?
I think it was actually originally set for 10:30 on page.
Mr. Marufo?
Page 5, Judge.
Okay.
In cause number 2019 DCV 0505, Hotel Sancho Panza LLC versus FT James Construction Inc. et al. Announcement of council, please.
Sylvan Lang and Megan Gillette on behalf of the plaintiff, Hotel Sancho Panza.
Cynthia Canales for Jordan Foster Construction on behalf of Harold Davis.
Michael Hirsch on behalf of Rooftoppers, Inc.
Deborah Fisher here for Stephen Nicky on behalf of FT James Construction.
Marwan Bhatti on behalf of Basque Celtic Inc. And I apologize, Judge, I have another cause number, but I had another hearing here at the same time at 10 o'clock as well, so I'm here on two.
Okay. Give me 1 second. I remember this case, but I cannot find it on Odyssey. There it is. Okay.
And my client, I'm sorry, Your Honor, we're appearing subject to our plea to the jurisdiction that we had filed.
Okay. That was filed on the 17th. Alrighty. Okay, so we're back. This actually left when we were still in person. So, status. Mr. Body, let me start with you. I see that was filed. I don't see that it's been set for any type of hearing. So are you requesting a hearing on that?
I'll be requesting a hearing, Your Honor. I've also had some preliminary discussions with plaintiff's counsel on maybe resolving our end. We're a much smaller party in this giant litigation. So that's if we can't work it out, we'll be asking for a hearing on this at the next available date.
Okay, so then I have us down for a status. Well, let me ask Mr. Lang, let me start with you. I just assume get us on some type of trial track, unless you're telling me different. So I have this be our scheduling status conference. I don't know why I feel like 1 year is not enough, but if you tell me 1 year, I'm happy to do that.
You know, Your Honor, it has been a long time since we had that first hearing. The case went up to the Court of Appeals for 2 years and 5 months. The mandate was issued about a month or so ago. Briefly, we have been as efficient as we can be, notwithstanding our informal abatement. We've resolved several of the claims. Those parties have been dismissed. We vehemently disagree with Mr. Body's position that there's any jurisdictional issue at all. And there was a very tortured history of service on his client during the pandemic. We can leave that for another day, of course, because we are trying to resolve with Mr. Body's client. I think that we could get discovery done within a year, but we've worked very flexibly with FT James counsel, Jordan Foster's counsel, and many of the others. What I would suggest we do, if it's permissible, is let me check with Myrna in the next couple of days, find out dates, circulate those dates amongst counsel who are active, come back to you with a proposed date if that works and a docket control order that works. We've done a lot of written discovery. We've exchanged a lot of project files. If we can resolve it in the next couple of months, we certainly want to do that before we incur 10 or 20 depositions and the relative cost. Even though we're in San Antonio, we've got a lot of El Paso matters and everybody works very cooperatively.
Okay. I mean, that sounds like an efficient way to start or restart. So I'm happy to bring everybody back on a scheduling status conference on March 22nd. A little bit of a delay there, just because of the court scheduling. And that will be at 10 a.m.
And would it be permissible still by Zoom?
For my purposes, everything is Zoom unless you request otherwise. Okay.
Excellent.
So far, that's what we're doing. So, and unless it's something contested that, it's just better handled in person. But on the civil side, that's pretty much. So we'll come back on March 22nd. Anticipate we'll do some type of scheduling from there. Monday. Who's that? Oh, there you are.
We have a bench trial for a 2018 case on the 22nd at 9 a.m.
Okay, so we can go then to the 29th. anybody have any issue with that?
No issue.
And again, it would probably be if you all are able to coordinate, something very quick, because if you all come up with some type of scheduling plan, I'm sure I'll be okay with it. So,
And I'll check with Myrna on trial dates tomorrow.
alrighty, sounds good. Sounds good. It sounds to me like we're going to be so far out that the court is going to have a lot of flexibility. I can't think of too much in 2024 if that's what we're looking at, but we'll go from there. All right, not hearing any issues with that March 29th date, then we'll go with that and see you all on Zoom then. Okay, if you need something before, you may. If you need something before then, just let me know.
Thank you, Judge.
Thank you,
Good to see
Judge.
you. Take care. Who's next?
Bottom of page 1, Judge. In cause number 2022 DCV 0054 Eduardo Contreras et al. Versus Carlos Nunez et al. Announcement of council, please.
Marwan Bhatti on behalf of the defendant, counter plaintiff Carlos Nunez.
Mr. Quinones?
On behalf of Mr. Eduardo Contreras.
Okay, and is Mr. Brown on this case as well?
Yes.
Judge, he's in CC7 right now.
Okay. So this is a motion to compel the deposition of Diane Favela. I'm assuming, I guess, since you all are announcing ready, this doesn't really affect Mr. Brown that much, or what are we doing?
Well, for me, it does, Judge. A third party witness. She's, my client's alleging that she took some of the money from the business. She is kind of a key witness, but we've already set the deposition for the 21st of February. I just would like the court's order so that she receives the court's order and is present by the 21st. So I fully expect that the court signs the order that she'll show up.
Did you provide a, well, let me ask Mr. Body. I mean, it sounds like everything's agreed, or we're hoping that it's going to happen, I guess. But do you have a position on that, on his request for an order?
Well, Your Honor, I do not want to throw a monkey wrench into this whole thing, but I'm usually pretty easygoing about these things. It's a motion to compel a non-party, there's a third-party witness. I don't believe she has any relevance. We've done 7 depositions already in what is a dispute over what appears to be like $6,000. I've been very cooperative. I usually agree to all dates. I'll sign off on orders. On this one, Your Honor, I feel like the discovery process has been, drawn out by the plaintiffs. They've taken unnecessary depositions. My client is paying me out of pocket for this. This is not an insurance case. This is not a contingency case. They pay me by the hour. We sat through 7 depositions already. Other than the plaintiff and the defendant, most of them were a waste of time, in my estimation. And my client's asking me, why are we going through all these depositions? And I said, well, they're entitled to as part of the process, and that's why I've not objected. But a couple key things, Your Honor, is number one is discovery deadline did pass January 7th. They waited to take the deposition of this non-party witness all the way through, I think it was October, November. I think they have all the information they need. At the same time, there were other key dates that the judge, that Your Honor, that you had signed off on the scheduling order, and plaintiffs had agreed, and one of them was mediation, and with Mr. Ancliffe. And I've tried several times to ask them, hey, we need to schedule this. We need to schedule ahead of time. Mr. Ancliffe, his calendar is backed up 60 to 90 days. He's one of the most popular mediators. And so I anticipate, Your Honors, that I have no real opposition on the motion to compel. I mean, if somebody's served with a subpoena, they need to show up. I would note that the motion to compel that they filed mentions that they try to confer, or there is a certificate of conference. It's in the very last paragraph. I don't see any due diligence by plaintiffs to reach out to this lady after she didn't appear. A letter saying, hey, you haven't appeared. please try to, why haven't you not shown up? You need to come out to the next deposition. I don't think they've done that work. I think they've blown the deadline. I don't see them cooperating on a mediation. At minimum, Judge, if you could admonish the parties to make sure that they comply with that and get it done on time. Like I said, I didn't want to be difficult about this, but my client's hurting. They're paying me money. And every time they come to my office, they remind me that they're paying me money. And so, and I know, Your Honor, that there was a trial date, I think April 7th, and
there is a trial date. And so you all are aware, we have trial set April 7th. So that's going to be one that doesn't fit on that date. I don't know if we'd addressed that before. I feel like we have the mediation deadline, and there is just
I believe it's March
8th,
maybe, yeah.
It would be the day before the final civil pretrial. Let me go back over there. Final civil pretrial is March 8th, so your deadline is March 7th to mediate. Why haven't we scheduled that? I mean, it's a month away.
Yeah, like I said, Your Honor, I've tried. I've looked at the calendar. I've thrown it out. Every time the last time we scheduled the 7 depositions, I think in October, November, I asked again, hey, do you want to mediate even the day before? I mean, they can do it whenever they need to before the deadline. I would like to avoid unnecessary expense. I've got separate issues because the court had signed a temporary injunction, and there's been a violation of some of those issues. I'm trying to resolve it with plaintiff's counsel. I've sent them a letter which has been unanswered, and that may result in a motion to compel. So I've got some bigger issues. Again, Your Honor, I mean, I'm willing to cooperate, and I don't per se have an issue with the judge, with Your Honor compelling this person to show up. But I wanted to at least give the court some context of where we are. And I'll do whatever the court deems is necessary, but I just wanted to let you know.
So Ms. Favela's deposition is set for February 21st. Is that right?
That's right, Judge. I said it. She's the only one of the 7 depots that we did that didn't show up. We subpoenaed her. I think that's sufficient notice to know that she should have been there at the deposition.
So if you will, I'm going to grant your request to order her appearance, and that will, the language on that, I haven't seen a proposed order, is that she appear on or before that date, February 21st, end of day. Okay, so if you would submit that proposed order, I'm going to go ahead and grant that. But with that said, it sounds like there's the potential for a lot of issues to come up before we hit our final civil pretrial. So again, I'm going to ask Mr. Quinones, what is the status of the mediation?
Oh, Your Honor, I think we're just trying to find dates. We have no opposition, of course, to sending, well, we have to go to mediation, and we're open to moving our schedules around. I think it's just a scheduling conflict, but I can find out exactly.
The deadline is firm. It's March 7th. That gives you a month, and Mr. Body is correct, at least in terms of the information I hear every Wednesday, is that the mediator schedules are very full. So if you're going with Judge Ancliffe, I gotta think, it's gonna take some luck. You can actually schedule something before the deadline. And so if that has not been explored, it really is incumbent upon you. It sounds like Mr. Body has been inquiring about that. And so that's a firm deadline. If there's some other way you all can resolve that or make some things happen outside of that, great, but we're on a short timetable here. So give me your order, Mr. Quinones, Mr. Body, Mr. Quinones, if either one of you have something that you need to file and things aren't moving, I don't know. You need to do it quickly because we'll have to turn it around with the court schedule in the next couple of months and the holidays, those kinds of things can get tricky. We might be limited time-wise, so please don't hesitate. File your motions, request your hearing so we can get it set. What else? Anything else?
No, yeah.
All right, thank you very much. All right, y'all are excused. Who's next?
Bottom of page 4, Judge.
Uh-huh.
In cause number 2021 DCV 2417, Antonio J. Diaz versus El Paso Healthcare System Ltd. et al. Announcement of council, please.
Mr.
You're
Melendez,
muted.
you're muted.
Al Melendez on behalf of the plaintiff, Your Honor.
Good morning.
Gary Norton from Las Palmas Medical Center, Your Honor. Cynthia Llamas for Dr. Crosby.
Michelle Obach for Jose Rincon.
All righty. Final status. Let me make sure I'm not looking at the right case.
We're set for the Friday before Easter, Judge. You told us at the last hearing it wasn't going on
Right.
this.
We need a new trial date. That's what the little notation says here to me.
Yes.
So let me go back. So have you all talked? Well, just give me a status. I know we're going to need a new trial date. So what's the status here?
Let's see, we, I think, I'm just going by memory that, let's see, the plaintiffs have designated, we did the plaintiff's deposition, his son. I think we did all the defendants, and I think we designated our experts. And so I think what's next is just, the big part is just deposing our experts. And I think there was some consideration of a physician-patient relationship issue. We have the same issue in a different case that's being appealed right now. We're seeing if the Court of Appeals will accept that issue, whether or not there's a physician-patient relationship under the same circumstances as this case. And that's kind of the status.
Okay. In terms of our current settings, have you all been able to discuss a possible or potential good reset date?
No, Your Honor.
Okay.
What we could do as prior counsel suggested and maybe get with your coordinator and within the next few days circulate dates amongst us. I'm just thinking that I'm kind of.
That'll work for me. And what I'll tell you kind of as we think of doing that is if we're looking at something that is say like a 3, 4, 5, whatever, 6-month turnaround, to me, that's kind of may not be that quick, but I feel like it would be quick. Then I would just reset the final civil pretrial, the docket call and jury trial. I bring up the final civil pretrial because I would still use that kind of as my goalpost for a mediation deadline. So I would really just look at those 3 dates pretty much. And then if you all need something in the interim, fine. But if you'll do that, I'm going to leave that final civil pretrial for now is potentially a time to reconvene unless we have something squared away outside of that. Okay. How does that sound? Okay. So I guess I mean to tell you we're pushing back that mediation deadline to whatever our new trial and final civil pretrial will be.
Sounds good, Judge.
Anything else?
We are pushing it back, Judge?
Yes, we are. April 7th is Good Friday. I just, for now, I'm leaving March 8th, basically, in case I don't have something squared away from you all before then. I'm checking in with you all on that date to see what's our new trial date and our new final civil pretrial, so we can use that as a guide for a mediation deadline.
I understand, Judge. I haven't had enough coffee, apparently. I didn't understand.
Me either.
Yeah, so we're coming back on the 8th unless we have an agreed date.
Yes, ma'am.
Sounds good.
Okay.
Do we need to contact Myrna, or is she here and will send us some dates proposed available today?
I understood that you all were going to do some of the squaring away of proposed dates, but I can ask her right now unless you all, I understood that you all would confer about potential good dates.
If she would just give us dates the court has, then, but we can email her.
Let's do that. Let's do that. We are filling up. And that's why I say do that, because it could be messy.
And Judge, would we be this is a case with experts for all parties, out of town experts as well. So would we be getting would be like a number 4, number 5, or where would we be on the ranking with regard to a reset?
That sounds to me like it needs to be specially set. So that'll affect what dates we have. Okay. Okay. Myrna, so we'll need to look for a special setting, and that'll make a difference. Okay.
That'd be great.
Alrighty. Okay.
Thank you,
All
Your
right.
Honor.
Thank you, folks.
Thank you,
We'll
Judge.
see you. Take care. We haven't